Our local celebrity just showed up.
I saw that. I let him in.
Yeah. Hi, John. You're muted.
How am I celebrity?
You're the local celebrity I'm referring to.
Okay, we are streaming on YouTube.
Hi, everybody.
Okay, Matt Goyne is just coming in now, so then we should have everyone.
Should we get started? Yeah, great.
Yes.
Call Franklin Township Planning Commission meeting to order at 7:03, March 4th. Public comment? No public comment. We'll move on to approval of last month's meeting minutes.
I went over those minutes and I didn't see anything wrong with them, so I passed them back to Mary and I think she issued them to the board. So, any comments?
They were pretty simple.
Yep.
Entertain a motion.
I'll make a motion to approve them.
We have a second, anyone?
Second.
Matt seconded, Mary. Any discussion? All in favor, say aye. Aye.
Hi.
Opposed? We'll take Mark's mouth movement as an aye.
Whoops. Oh, there we go. Sorry.
All right. Motion passes. I'm not looking at the minutes. Go ahead, Mary. You're on mute.
I just want to make sure I got the count on the motion, how it passed. Is it 5-0 or is it 4-0?
We're all here,
Five.
right? Five.
Five.
That's what I got.
I don't think there was anything else on the agenda. I don't have it in front of me except to keep going over the editorial and legal analysis. And
Right.
we're starting on 27-204.
I believe we're up to 205.
I thought 204 was the forestry. Did we finish forestry or skip it?
It had a little discussion at the end, I think.
I think we went through it and then I think we were looking for the definition, but I think we went past it. My recollection.
I think we were going to add, do a little research and come up with a definition at that point.
Yeah, I think it was going to get passed for some more review because I'm kind of like Jeff on this one. You know, I'll be the last one to beat a dead horse, but when you hire one of these outfits to come in and clear, to me, you know, the what's defined as forestry management, the timber operation could roll in that, but it almost feels like it needs something that you just know they're not going to walk away and leave it looking like a bomb left it. Is that?
Well, just so you know, there's an area up on Route 1, I believe it's Pennsbury Township, that they
Oh,
did a lot
it's
of.
right in Chad Ford. Yes, ma'am.
Yes, they did a lot of
So-
clear cutting there, and the township contested it. And what they found out is that it's considered agriculture and it's protected under the acres law. So we have to see what we can do and not do with that. So we're not challenged again.
Did they sell the wood or did they just simply clear cut it to sell the land?
I haven't seen it. Matt, do you know if the wood is still there or?
They selectively took what they wanted, and then the debris that's left over, I think, is kind of what Jeff says. You know, they go through, and when they leave, and there's a whole lot of piles of stumps and, you know, just the limbs and things that are left there for the future.
A lot of times that's the agreement with the landowner. And oftentimes they go in there and cut up the remainder for firewood themselves. I think the bigger issue is the fact that they leave a lot of their rutted roadways from the equipment, and it gets very close to the riparian buffers and wetlands and streamland. However, as Joan pointed out, that's something that the conservation department handles, and Acres was more than happy to point that out as well. And actually, they are the ones at this point who are supposed to be managing it. So we could find it be a little overly restrictive with Acres if we start saying too much about it.
I mean, we didn't make out too well with them the last time.
Yeah.
Yeah, but in this case, we're looking to the state to support.
So do we start with the definition of forestry?
Why don't we try and
We're still back talking about question 4, right?
Yeah.
I must be missing some pages because I'm not finding what you're talking about. What page is it on?
30.
32.
In the book, it's
30.
on.
No, 30. 30. It's Jeff's.
Oh, okay,
page
got
too.
it. Definitions, yes.
But in this case, we're depending on the state to be monitoring proper forestry procedure, correct? As opposed to asking them to disallow a use, which is the last time we were involved with Acres.
Well, but the point that Pennsbury was making is that the state considers it agriculture. Timber harvesting is agriculture. So there were limited restrictions you could put on them.
Right. My understanding is it's not that you can't do some restrictions, it just can't.
Yeah.
They
Well,
kind of has to
prohibit the
pass the
activity.
mustard with Acres.
And I think they look at to see how far or how much of a restriction it would be. I think they would be understanding for something, you know, a small amount. But as I said, what happened the last time, we were well beyond what we should have done. So they didn't even want to think about it. So as long as we can make an argument that we feel we're right, then
Can
You know,
we can we ask the state for their, what their regulations would involve? Would they share that with us, or would it simply fall to a legal aspect and we don't know what it's going to be until someone sues?
I think they provide some direction, but basically what they're saying is as long as they go to the conservation department and get an approved plan, that's satisfactory.
So do they have an approved plan for what they did in Pennsbury Township?
Yes.
So what's there now, which is an eyesore, is acceptable to the state, is what we're saying, right?
Yes.
It's unacceptable to us, but it's, as a result, it's unlikely we're going to be able to do anything if that's what's acceptable to the state. Does that seem appropriate?
Well, we may be able to make some requirements, as Jeff said, on the road, the entryway and making sure there's not mud brought out onto the driving path. But as far as actually taking down trees, I don't think we have a say in that. But we can do some more investigating.
But
So
say,
should we-
is there any way you can put some sort of, maybe a little it's the end use after the trees have been harvested? Is there some way to put a timeline on turning it back into the management of forestry? Because at that point, you're starting a new forest.
Right. Right. It's not really farming if you just, it's mining if you just cut it down once and don't.
Exactly. And then now, once you clean all this up and redo the roads like Jeff says, or clean up the mess and replant seedlings, now you're going back into the management, to me, of forestry.
Yeah. Which is fine and good. That actually encourages people to grow trees.
Yeah.
But if you
Sounds
read
like
the
we could really use
definition,
an education from the state.
read the definition of forestry. It's the second paragraph in the book there, and it doesn't. They're not saying you have to plant it back.
Yeah, that's exactly right. So I think
Right. So if you're left with that land and those piles of things, you're left with that.
Yeah, I think the only thing that Jeff said is if we could do something relative to the mud in the roadway that they put in, if we limit it to that, that's probably as far as we're going to go without just spinning our wheels.
Yeah, a lot of the state
Can
game
you
commissions, when they do.
Yeah, we could go around and around tonight, I think. I
Right.
think, Joan, if you can do some research, whether that's somebody from the state educating us or whether it's even,
I can
LTO.
reach out to Pennsbury too, because they did have to deal with this and see what they were told and how they ended up. I will reach out to the state also, but I probably wouldn't hurt to talk to them.
Doesn't the word cultivating indicate that they would need to, that's part of the process? I would think that's part of the definition, cultivating being.
Again, we all have opinions, but it's a matter of what the law would support.
Yeah.
I don't know if we're going to get through that tonight, so maybe we should move forward.
I think at this point, they're with this code analysis, they're just simply saying we better add a definition. That's not developing a whole ordinance for forestry. They're just suggesting we put the definition in for now.
And we want to underline and highlight cultivating.
Okay, well, we'll do some more research on that. So
Underline, italicize, bold. Right?
If it
but
if
you
it
have to-
happens to overlap harvesting, that would be okay.
So let's move on to 5.
Oh, I got to turn the lights on here.
And the suggestion is to have the solicitor review.
Yeah, this is another wonderful suggestion, there are some definitions without specifying just how many there are and just which ones they are.
My personal comment on that was, yikes. To take the time to go through every definition, I think that would be very exhausting, and I don't know, we haven't run into that many problems with definitions at this point. If one came up specifically, I could understand it, but just to review them, I think that could be tough.
Well, aren't they talking about the definition of violation?
Yeah, and modify and modification, which has been defined as having a specific sense with respect to wireless communication facilities.
See, and in our zoning book, the definition of violation refers to floodplain management regulations. But there should be there's other instances of violations, I'm sure, right, Jeff?
Right.
So that's something maybe Mark would have to give us a generic definition to cover everything.
Well, I got the sense from reading this that they weren't so concerned about the generic definition of violation as just clarifying that the definition of violation is the violation is being defined only in this restrictive category. So
yeah, it says the failure of a structure or other development to be fully compliant with the community's floodplain management regulations.
right.
So that's strictly talking about the floodplain management and
Right.
elevation. So again, there's other times violations come into play.
I would think a lot of those would be common sense. So, in fact,
Jeff,
I know,
Jeff
yeah, I
would
know.
disagree
Well,
with you on that one.
yeah, right. Well, I'm sure in the moment you ask a lawyer, you'll hear a lot about that. But yeah, I mean, I just wonder sometimes if we need to if these are really highly specified uses of these terms, such that they need to have specific definitions for the the area, but without actually sitting down and reading the whole section of the ordinance where they're used, it would be tough to determine that.
But as I said, there are other violations besides
I
this
understand.
floodplain.
Yeah.
So, and Jeff will, I think, agree with me on this, that if it's not here in writing, then it's hard to enforce, right, Jeff?
That would be correct. I think what Paul was saying, though, I think they were this was a good example. And it seemed like as they were saying there are some definitions, and this is a good example of it. And I would say it would be good to clear this one up and like that they pointed it out. For some reason, it was added in 2017. I would be curious as to what exactly that ordinance was.
That's the floodplain ordinance.
But what we change at that point to make it important?
Well, it was, I have to get that out, but that could have been just one of the definitions. And the other example they give there is modification or modify. If you look that up, that only relates in our book, only relates to the cell tower, the wireless communication facilities.
Well, should we have Mark just review those two?
I agree with that.
Okay.
There's got to be some generic definition that would fit in most situations, because you can't cover all the specific situations because something else is going to come up, It's got to be something which is somewhat generic.
Well, right, and if for this one, it says modification or modify, I mean, couldn't you just give the definition of what that means? And if somebody's going to modify whatever it is.
That's what I'm thinking, maybe, and then maybe that's the legal people can give us a generic definition.
Okay, I'll put that in Mark's pile.
Because you can never cover all the situations that are going to come up. It's impossible.
There's a phrase that dictionary writers will use, or the like, or etc.
Yeah. There's got to be some generic definition which stands some legal grounds, and I'm sure we can get that.
I would be surprised if we needed to define violation, frankly, but
I wouldn't want to.
yeah.
If you leave it out, basically you would just go to a definition of violation and it would be the
Right.
general accepted use. But as soon as you specify it like it is here, then it presents a problem.
So you think we should take it out?
Let Mark decide.
We would have to do a little research on that. Like I said, why they connected it to those two ordinances when they were adopted is what we would have to look into.
Okay.
All right, we'll have Mark look at those two specific.
Okay,
Moving on to question 27.6.
this is Chuck's favorite definition.
Yeah.
Not more than 4 unrelated persons.
I just think we just leave it the way it is. We already, everybody talked about it, so let's just leave it the way we have it.
So do you want to just leave it as it is?
That was just me.
Well, I'm asking everyone else,
I'm okay with that.
because there is a box for that. Do not revise.
Okay with 4?
We talked
Okay.
about it for 2 full meetings
I know.
and
Well, Matt wasn't involved. Maybe we should relive it.
No, sir, it looks fine. I'm going with the consensus on that one.
All right, we'll check the leave as is box.
Okay,
Question 7.
oh, this is just a change of name.
Yes.
So that
Yep.
we should revise
Yes.
to the
Fine.
correct name, right?
sounds good.
Yep. Oh boy, back to timber. Question 8.
I looked over that and that's correct to what they're asking us to do.
They're just asking us to change some numbers that we have mixed up.
A reference.
Yeah.
Yeah.
Sounds good.
So then is it the 27-030, Jeff? We can talk about that when you're in
I
the,
can, I'll double check the numbers, but I know when I went over it, what they were saying is what we needed to do.
okay.
Okay, question 9.
That sentence in yellow, that is misworded. They probably should have put a period at right after chapter. And then simply said, notification shall be valid. Wait a minute. Yes, notification shall be valid if the owner and occupier of the property should.
Duly
What if you just
notified.
take out further, Jeff, and say no, notification of the owner and occupier of the property shall be valid if mailed?
Yes, that's correct. I'm
Okay,
got a little confused there.
okay. So we got that. We'll take that out. Okay.
Should that be regular mail or priority mail or certified mail?
It's usually certified mail.
Certified.
Yeah, I would think that would be better than regular.
Does it
You
say
think?
regular?
It says regular there.
Well, whenever I send out a violation, I always send it certified. They're simply saying it's allowed to be regular mail. I mean, if we certainly can change it.
I know when I send things out where I've got to prove somebody got it, I send it out certified.
Yeah,
It's an issue of practice.
Yeah, but this is the requirement. Why bump up the requirement?
Right. So if you put certified in there and for some reason we send regular,
It
It's
doesn't
not
go.
valid.
All right, then leave regular.
Okay.
The problem is I'm running this business and about 1 out of every 2,000 or 3,000 parcels I send don't get delivered ever. So there's about, there's that kind of a chance, and I do send them, with barcode following them, they just disappear. So there's a chance of it happening. It's a small chance, but it's a chance. But that's okay.
Yeah, if we write in,
Norm.
John, if we write in here that it needs to be by certified mail, and there's a court case, and the question is, did you receive it? And they say, yes. How did you receive it? By regular mail? And the lawyer can say, yeah, but they were supposed to do it.
Well, leave it
Certified.
regular.
Yeah.
Leave it regular. That's what's worked in the past. Leave it.
just leave it mail, take out regular.
Yeah, then you could do either way.
Yeah, that'd be fine. Take out regular. That would work.
And we made a change.
Yeah. Is that a problem?
No, that's good. That's good.
Let's talk about weeds. Whoa. This one
It's
has a
not really
vi-
weeds. This section, by the way, is tied in. This question is also related to question 27-023. Mainly because they're suggesting that we eliminate this penalty section in favor of what's at whatever other section it is, 27-2304
What page are you?
subsection 2.
Before we go there, can we go back to this? When we got rid of regular, it really changed the nature of the sentence. So I think we got to take out more than that. Because we say if mailed by mail to the address.
So just get rid of by regular mail.
Right, we just say if mailed to the address. Just take out by regular mail completely. That makes it cleaner. And then we can get back to the other issue.
If you do that, then, John, do you want to end it by saying, or by personal, or delivered personally to the occupant of the site for parallelism?
Fine. There you go, the editor.
Well, I guess I would just tend to do that because it seems a little strange. It should be, shall be valid if mailed to the address of the owner,
Or delivered, you're right.
given for real estate tax purchase, or delivered personally to the occupant of the site.
That sounds good. We all agree with that?
Yes.
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 So Paul, are we going to start talking about invasive or noxious vegetation, or is it a different?
It's not really about a noxious vegetation. It's really about what the penalty for the violation will be.
We have a penalty also.
Yeah.
Yes.
Apparently we have a broad statement of penalties, which, let's see, if you look at page 42, that's the section that they're suggesting we eliminate.
What
The
page did you
section-
go to?
Page 42.
42.
42.
Yeah, that's the enforcement of penalties.
Yeah, it says enforcement remedies. So basically, the enforcement remedy specifies the penalty, and so what basically they've said on page 35 is this section has a penalty in chapter 27, section 2304, subsection 2. Well, that's the section that's given on page 42. And so they're suggesting that we could delete the section on page 35 because it would be covered by the section on page 42. At least that's how I read it. Except that when you get to 42, they're suggesting we change the section on page 42 that would actually bring it more in line with the section on page 35.
So do we leave page 35 or modify that and then just drop 42?
No, I will basically, I think the end result is probably to go with a variant of their suggestion on page 42 because you don't really want to drop the one on page 42 because it's enforcement remedies for the entire chapter, I believe.
That's correct. You can't eliminate that.
Right. So basically what they're saying is that the section, the penalties, which are enforcement remedies on 35 are redundant and somewhat in conflict with what we currently have for the entire chapter. And so they were suggesting eliminating what's on page 35 in favor of what's on page 42, but they're also suggesting modifications to what's on page 42 that would ultimately cause the penalties to resemble those penalties currently provided for on page 35.
Yeah.
Yeah, I would agree with you on that, Paul, that we could eliminate what's here on page 35.
Anybody have any disagreement with that?
No, but how many other places point to this particular section or code?
Not too many.
42 you're talking about?
No, on page 35, if we eliminate that, how many other places point towards that we have to change and point them to page 42? That's something we'd have to do the trail on. You follow me?
I doubt that there are too many places, because why would you refer to growth and weed violations for other violations in the
I agree.
ordinance?
I just don't know what it is, what the,
So the solution to, I get what you're saying, John. The solution to that is basically to turn what's on page 35 into a pointer to what's on page 42.
I think that'd be, yeah.
Just say that penalties for something like any person, firm, or corporation who violate any provision of this part shall be subject to the penalties outlined in 27. What is
I
that?
think-
27-2304 subsection 2.
That keeps it cleaner just in case.
Yeah, no, I understand why you're saying that.
Yeah, so I got no problem making that change, Paul.
You think that works for you, Jeff?
That'll work.
So we're really gonna throw somebody in jail for 90 days because they allowed invasive species to grow?
You want to talk about bamboo?
That's what I was
Um,
hurry up.
Well, I'm pretty sure we have a hard time finding very much that's left that isn't invasive.
I
So,
don't know about that.
No, I don't think that's the case. I think
No.
there are more native species out there than you realize.
I think that's right.
Jeff always
Osei,
warns them
there's an
before they
awful
go to
lot.
jail.
What,
Yeah.
do we have a list? I mean, that's substantial on, it says invasive and noxious, that there's almost, there's been a lot of stuff that's been introduced to this area that is
Yeah, but
not
the one that
native.
really causes problems is the bamboo. Jeff, wouldn't you agree with that?
It is a big problem, yes.
Yeah, but it doesn't, that's not what the ordinance says. The ordinance says invasive and noxious. So therefore, you can say, well, we have our, our favorites that we don't like, but that's not what the ordinance is
Let me see
saying.
if there's a definition of noxious weeds.
Osage oranges fall into that category, and
Especially if you
Art.
get hit in the face with one while riding in a convertible.
Yeah.
I know somebody that happened to.
Noxious weeds. Okay, there is a list of them in the definitions. One of them is marijuana, chicory, Canadian thistle. That's really bad for the farmers. Multiflora rose and Johnson grass.
The bamboo's not in there.
No. But the
Well,
state of
remember-
Pennsylvania considers it a noxious plant. And we do have a bamboo ordinance.
We do have a bamboo ordinance, yeah, that's right.
Yes.
but we should probably just quote Pennsylvania instead of saying invasive or noxious.
Well, this says shall include, but not limited to.
Exactly.
So it does cover more.
I don't know.
You probably have to say marijuana without a permit.
Wouldn't that violate the acres law?
That's considered commercial. That's not agriculture. That has to be grown inside.
Hmm.
We had people look into that already.
I bet.
Yeah, but hemp can be grown outside.
Yes.
Mhm. It's legal.
That's legal, yeah.
Chicory? That
Yes.
seems
Yeah.
crazy. It's a pretty innocent little weed.
Yeah, I wonder why it's in there, but it is, I mean, a dandelion's invasive too,
Is
and
it?
non-native. Yep, invasive and non-native.
Wow. Yeah, it's hard to find. There was a horticulturalist out there that said, maybe we should stop worrying about figuring out what's invasive or what's native. Not what's invasive, but what's native, because everything's been spread around so much that you already got what you got, and to try and go
Go
back.
backwards.
Yeah, it's just impossible. But I mean, the word invasive, yeah, I mean, that's important, but are we really going to throw somebody in jail for 90 days for allowing weeds to grow?
Yeah. Having
Well,
some,
you'd have to take them to court to get that result.
Well, I know the farmers get very upset if the thistle isn't controlled, because we had at one time we had some in the Goodwin Preserve, and we heard about it. So we had to deal with it, because it really
It's
has
not
an impact
good.
on the farmers, right?
Yeah.
It's not good.
This is nasty. I know if I see it, I get rid of it. Yeah.
So we really didn't get in, these weren't intended to get into a list. Do you feel you need a list, Jeff, at this time?
No,
Okay, do we want to move on to question 11?
Yes. I vote
I'm
for
fine
yes.
with that.
their response that it appears that the reference should be subsection 2 is correct. So that should be changed.
So that's revised as suggested, right?
Yes.
Okay. Question 12. Revise as suggested.
Yeah, they're right on that.
Yes, they were.
Okay.
And then 13.
So they're obviously right that the bond isn't released by the applicant.
it's to the applicant.
It is to the applicant, but the question is, do we need to specify who is responsible for releasing the bond to the applicant?
Well, does it say that it's given to the township?
Right, so can the township manager or the zoning officer go ahead and release it? Independent of a vote of the Board of Supervisors.
Question.
Well, it says to the removal of all facilities to the satisfaction of the Board of Supervisors.
Right,
I certainly wouldn't release a bond, nor do I have the power to, as a zoning officer, to do that.
right, no, I'm just wondering whether it should specifically say that, or if that would be considered redundant, that's all.
Well, it says to the satisfaction of the Board of Supervisors, so they would have to vote on it, at least
They would
make
have to
their,
vote that they're satisfied.
yes.
Right. But they wouldn't necessarily, the way I read it, I'm just saying, they don't actually have to vote to release the bond. They have to vote that they're satisfied with what's been done.
But that's what we do with even like for subdivisions, when
Yeah.
developers come in and the board votes to release the
Yeah,
funds.
I know the board generally votes to release the bonds as an indication of their satisfaction, but they actually don't,
They
it's
don't do it.
interesting the
Who's
way-
ever holding it does it.
Yeah,
So, and this could be the same in this case, who's ever holding the bond.
Yeah, that's true. All right, so it should be vague.
Revise as suggested.
Sounds good. Question 14.
Update name of department.
Mhm.
Yeah, needs to be changed. So is that okay? Is everyone good with that?
I would just let Mark weigh in on that.
Well, I just know you don't use those terms that are in there. So you have to,
Yeah, they
They-
changed. I mean, the name of the department has changed.
Yeah.
So we're referencing an incorrect name.
Yeah, I don't think Mark has to.
yeah,
Yeah, I don't
that's
think
just
Mark
changing the
needs to.
name.
The thing, we have a number of instances like this. I just wonder if there would be some formula we could come up with that would prevent us from constantly having to make name changes.
I think as long as people change names, you're not going to be able to do that.
Yeah. So update name.
I'll talk to Google about that. They can probably geo-track it.
An additional dwelling unit. Didn't we just deal with this?
Yes, this is just a grammar.
Our land
We did-
development plan is not defined.
Right.
Now, what's defined is land development and 4 different kinds of plans.
So basically, if we just drop plan out of the sentence, it would just simply say, shall require land development as defined in section 22-202.
Is the definition, see, I thought the definition doesn't indicate you need to do anything. I'd have to, what is it? Where are definitions in this?
Should it be that it shall meet the requirements in section 22-202?
I don't see what their exception to this is. Because it changes a verb to a noun. What's the big deal? The land development is defined and it's just a land development plan. Why are they saying that's, do we really need to have a definition that says land development and then land development plan that would reference land development? That's just getting silly.
Leave it the way it is.
Although I tend to agree with you, since they kicked it out, I would have the solicitor sign off on leaving it as it is. Or the other option is to get over specific and then say shall require land development sketch, preliminary, and final plans as outlined. That you get around it that way, they're all defined.
Well, what if we simply say require a land development plan as defined as per chapter 22?
All right, well, I was trying to.
Can we just take land development out and just leave the word plan in?
No.
No, okay.
No. We could take out plan. Take out A and plan.
A and plan.
Okay.
that good? Remove A and plan?
Yes.
Yep.
I don't know. What I'm trying to do is read the definition of land development. See, I don't think it makes sense if you land development is just a description of activities. It doesn't specify how you go about doing them.
That's why I go back to it's a noun. Just leave it the way it is then.
If the intention is to require a land development plan as we know and love it,
Mhm.
by taking out plan, you're not requiring a plan.
Leave it in. We intended to require a plan.
Yeah, no, I don't have a problem with that. All I was saying is I would just if I had a vote on this, and I don't, I'd point out, I would just have Mark sign off on leaving it as it is, in case he sees something there that we don't.
It seems like I have no problem with doing that. Because I like it the way it is actually myself.
I like the way it is also.
So do we all agree we like it the way it is? And let's have Mark kind of vote on it? Jeff?
Yes, that'll be fine.
Dave? Anybody?
All right, we're gonna have Mark review it.
Okay. And leave it the way it is unless he objects to it.
All right. I think they brought up the next one because wineries should have larger signs.
Let's just drop winery off and just make the signs larger in general.
Well, I guess they wanted you to have two signs because it's in two different spots here.
Right.
Right.
So we just have to remove one, right?
Yeah, I would get rid of E only because you're going to re-letter more sections if you get rid of C.
So we'll remove E.
Right.
Okay, 17.
They were correct in their suggestion to change C3 to read 27-2005. And then the first sentence should be removed of section D.
So that's revised as suggested.
Yep.
Yes.
Yes.
$18.
It should reference section 2003, like they're saying, exempt signs rather than temporary signs. That is an error.
Revise as suggested.
Sounds good. Yeah.
Yep.
Can I say, I think that the sign section is a logical mess. I was looking for parallels and, oh.
You may. But
Well, there is one thing you
what
could
is
say
it?
about that.
19.
Before we move on to the next one, the signs in section 2003, exempted signs, they're permitted in all districts without question and without permit. It's just road signs, trespassing signs, etc.
Which is why it's a logical mess.
You actually could delete that line altogether because there's no reason to reference back to it because they're already permitted in section 2003. And you could also delete it in section 2008 as well. That signs in the commercial district. It's just being a little redundant because they're already permitted. I'm saying they're exempted for a permit because they're automatically permitted.
Can we fix that now, Joan?
We can just delete any sign under section 27004 in section 27209, and also delete line A in 27208.
Sounds good to me.
Yeah, I really liked A, Jeff. I'm going to miss it.
Say that again?
I said I really liked that 272008 1A. Is
Yeah,
that the one you're referring to?
Yeah, but you don't have a vote.
No, but I liked it because it was doubly redundant. Not only did it permit exempted signs, but it also additionally permitted any sign permitted under the section in which it was located, which is, just in case you're confused, all the sections we're about to list, all the signs we're about to list are permitted.
So we're going to go along with Jeff's recommendation. Is that what I'm hearing?
Yeah. Mary, are you clear on which sections?
What was the first one, Jeff? I have the second one. I don't have the first one.
Well, we were discussing 27209.
Oh, okay.
So we could eliminate 1A
Got it.
and then go down to 27208 and eliminate 1A.
Okay.
As long as Joan knows what's happening, I'm good.
Yeah, I got it.
Sorry.
I have it tonight. That doesn't mean I'm going to have it tomorrow.
I think we should all be using a Google Doc at the same time since we're doing Zoom, and we could all change it all at once.
Don't go there.
We could have comment wars.
We did that in our business 20 years ago, and it was a nightmare.
Are we done with question 18?
Yes.
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 Yeah. Okay, 19.
I would just like to say in regards to this, we do not identify and register non-conforming uses and structures in the township. It wasn't ever done before I came into the township, nor did I ever sit down and try and figure out which parcels and which buildings are non-conforming.
So since the MPC doesn't require it, you just want to delete this whole section? Because this says you're supposed to compile a register.
Well, I think before we delete it, I think Mark should probably say okay on that. And just in case there's some kind of some snag we'd run into. I mean, I would be open to deleting it simply because it's never been done.
I agree.
So that just puts the onus on the building owner to prove that it's non-conforming and it's been non-conforming. As we've always done, I believe.
That's what we've always done.
So we'll delete it with the solicitor's approval.
Okay. We're a little behind on the next one.
I can't answer this.
Well, it says it was repealed in 2008, so do we have a choice?
Has it been
Well,
an issue
was it-
since, has it been an issue since 2008? Have we had any problems with that?
Well, this says an appeal has to be made within 30 days after the effective date of an ordinance.
Right, so have we had any of those situations?
Not to my knowledge.
No.
So if it's been repealed and we haven't had it, does that mean we repeal it?
Yeah, we just delete it.
Exactly.
But have they provided another mechanism to do the same thing?
Aren't they saying that it's not valid to limit it to 30 days?
No, see, I was trying to figure that out. I mean, what was if it was repealed, what was the significance of the repeal? Does it mean that such challenges are no longer valid at all? Does it mean that they can't be handled by the zoning hearing board? Or does it mean that they can be made after 30 days?
Well, the zoning hearing board does not deal with the challenge to the to a new ordinance, to a zoning ordinance. You know, if the board passes a new ordinance, adopts a new ordinance, someone has a right to appeal it. But as far as I know, it does not go to the zoning hearing board because they have nothing to do with approving it or adopting it.
That's why taking it out makes sense.
But that's what it says. Currently, it says that they have the responsibility to hear challenges, exclusive jurisdiction.
But they don't.
Okay. So
well, maybe to hear the challenge.
Yeah,
I don't know.
If it's specifically on a specific request, then it may be argued that ordinance doesn't apply, but the zoning hearing board says, yes, it does.
No, it's the challenge to the ordinance, whether it
was validly adopted and constituted.
Yeah, but I think this probably is one Mark should weigh in, don't you think?
Yeah.
I think that's what Jeff suggested.
Okay.
21.
Yes, 25 is titled Natural Resource. So in my opinion, it should be revised as suggested.
I agree.
So the correct one is environmental resource protection?
No,
No.
No, the
Yeah.
correct one,
it's natural.
natural resource.
Natural.
Okay,
Revise as suggested.
okay.
A22.
Zoning hearing board.
So one thing I'd just like to point out is that the section B here is just the section we were talking about concerning challenging the validity of an ordinance on the basis of defects in its passage, et cetera.
So the zoning hearing board does hear that if somebody challenges the ordinance?
No, all I'm saying is that this, if the change that they're suggesting here is to be consistent with the change suggested on the previous page, which was question 20 there,
Right.
then the B should be eliminated entirely from this list of sections, subsections. In other words, depending upon what Mark decides, if that subsection goes, then B has to go from this list as well as H.
Right.
So we wait for Mark to give his comments and then review this.
We take out H, and
Well, there,
if B is removed, we take out B.
Right.
Otherwise, we just leave it in.
Okay, ask Mark.
well, their comment about the letters is correct.
Right, about H. Yeah, H isn't there.
So if Mark says it should stay, it should be revised the way they suggest.
Right, I'm not disagreeing with that. I'm just saying that you need to be aware that this has to be changed in tandem with what's being discussed under question 27-020.
Reference to.
Do you have that, Joan?
No, I'm trying to figure out what they're talking about. 1A, B, C, D, E, F, G, H is there.
So there is no subsection 1H.
In 2202?
No, oh, yeah. No,
Yeah, there's no
keep-
All right, 2202,
they
there
can
is no
res-
H. You're right. I was looking at 3.
Yeah.
Okay, okay.
Well,
So
not only
then-
that, but they made mistakes in some of their own comments.
Yeah, I want to send it back. I see that. It's a double D in the middle there.
Yeah.
Yeah, the double D.
Oh, it's not just a double D. It's
Let's-
27-2002
Let's
instead
send
of
it back.
27-2202.
Let's mark it up and send it back.
So there's no H, so we'd have to take that out.
That would be H and B, correct, Paul?
It's B, maybe. B depends
maybe, right.
upon what the decision for the question on page 40, that's 27-020. So B may have to come out too. And
If
then you
Mark-
get to re-letter all the,
Sorry, I'll mute for a little.
Section, section 2202 starts out by saying the zoning hearing board does have exclusive jurisdiction over that section we're talking about.
yeah, I know it does. That's the,
I think it has to do with once something comes before them, they get to determine what applies. It gives them the right to determine what applies as a board. That's why Mark has to
no.
review it.
I mean,
Yeah.
it's, in some ways I agree with you, but the fact that, well, first off, the comment says the section of the code, the planning code it was based on was repealed in 2008. But the other thing is you're really challenging it so soon. It's not going to come up in the context. This challenge won't come up in the context of trying to do something with your property. You're going to object to the ordinance 30 days after it was passed.
What says the process of enactment or adoption is what you're objecting to.
Yes.
Right. But you're making that challenge 30 days after the effective
before-
date of said ordinance. You have to do it. You're challenging the ordinance. You're not challenging, you're challenging the ordinance, but not in the context of trying to do something with the property. You're challenging the ordinance that's been adopted after it's been adopted.
Oh, yeah, because this is after the effective date of the said ordinance.
Right.
Well, that's why they repealed it. Yeah, that doesn't work.
Well, to me, it's
2703.
definitely a Mark question.
Right.
So we're getting back again to the solicitor reviewing it.
Yes.
Yes.
So the solicitor is reviewing 20, but now the question is not whether it needs to be deleted or not, or is it, are you keeping it in?
No, the question, it's entirely up to Mark whether or not he takes it out. If he takes it out, we need B taken out.
On number 22.
Yes.
Okay.
So we're on to 23.
That's the enforcement remedies that we were talking about before.
I really see that as a political decision.
That's what I'm thinking too.
Well, they're saying that the MPC now says that there's no minimum, so the maximum is 500, so we could, you know, go as low as we want if there's no minimum.
Well, they're also paying court costs. Aren't the court costs going to be a lot more significant than whatever fine it is.
The court cars, it says paying attorney fees too. That's a big
Yeah.
plus. Wish we
Yeah.
had that for something the Harb's working on.
But yeah, so the,
Well, that's an interesting question. Why don't we?
We're looking into changing that.
Yeah.
I almost feel like historically the $300 was supposed to cover that, and now it doesn't cover that. And I mean, I don't know.
Are there other ordinances that specifically put dollar amounts? I thought we tried to leave dollar amounts out of the ordinances and the supervisors passed kind of the fees annually.
Yep. Exactly.
No, these are enforcement penalties. These are not fees.
Well, penalties, fees, I mean, because eventually $500 will be $5.
No, but that's $500 a day, right, Jeff?
Yeah.
Yes.
So, I
And
mean,
some
that
of
can
your-
add up.
In some of your standalones, we have it for 1,000 a day. This is actually low. And of course, they have to be found guilty, and then the judge has his. He doesn't always
work
even
that way.
define order.
Do you want me to ask Mark about this one?
Well, should we be setting the levels
No.
as a planning
No.
commission? I don't think so, are we?
Now that gets back to my comment. I think it's a political decision.
Exactly.
This isn't still for the weeds thing, is it?
We're in the
No,
weeds.
but it's related to the weeds thing. This is where the
Right.
weeds, this is what the weeds
Came into.
ordinance would now point to. The weeds, that subsection would now point to.
But I don't think it's a planning commission issue to set up what the fees or fines should be.
Yeah. And I think we all. Yeah, chicory is not that bad of a weed, so should we really be charging $500 penalty?
A day.
Let's have Mark.
Okay.
I don't think we're very sensitive to this $500 a day chicory.
In regards to chicory, most people mow their yard after they get a notice of violations.
Unfortunately, it cut out on me.
Typically, most people cut their chicory down as soon as they get a citation from the court.
I'm sure some of them think it's a wildflower.
I think it goes in my coffee.
Only the root, not the.
Yeah.
24.
We no longer require the registration of contractors, right, Jeff, because the state does?
That's correct. As far as I'm concerned, we could delete this unless somebody sees a.
Which was 05. 05.
Are we still looking at the building licensing of contractors?
It's got like 9 subsections.
Yeah, but the one they're talking about is that it says Franklin Township, that they can't do any business without first obtaining a license from Franklin Township, and we don't license contractors because the
Right.
state does. So that section should be deleted.
I agree.
Yeah, there are other sections that would need to be deleted as well.
What other
Section
sec-
3 talks about collecting a fee for the license.
Okay, so that's,
I
One-
think the whole section 27-2305 should be looked at for either deletion or severe reduction, because so much of this simply deals with the licensing process.
well, the whole thing
fee,
does.
yeah, all 9 subsections.
Yeah, so we could just delete the whole thing. Right?
Yes.
Yeah, it looks like it.
Well, they're all dealing with the license.
Well, yeah, and defining who is a building contractor, et cetera. Yeah.
Okay, so we agree to delete it, I think.
I say yes.
So we'll delete it. Mark? Matt,
Yes.
John?
Yes, delete it.
Yes.
Okay.
Hmm.
25.
So they said there's no
Thank you.
271309.
Can I just make a suggestion? Unless you want to potentially search for a lot of stuff, you might want to reserve that section when you delete it, because it's immediately followed by permits general, then by building permit, then by use and occupancy permit. And if there are cross references to all those cross references are going to go out of whack.
Well, just quickly looking at some of those, they are dealing with permits, not the licensing of a contractor.
No. What I'm saying is that when section 27-2305 is deleted, you might want to retain the section and label it reserved.
Oh, yeah, we do.
Okay.
You don't take it all the ways out. No.
Because otherwise it's going to
Yeah,
throw
you have
this
to
whole-
redo everything. Right.
Right.
Do you just reference the state one in that section, or?
No, it just would say reserved for future use.
Okay.
Okay. The zoning permit. There is no 1310.
They are correct. Neither 1309 and 1310 don't exist the way they say it. I think it should actually refer to section 13032, which is part of the flood hazard district. And it talks about permits that are required in the flood hazard district as defined by FEMA and FIRM and Franklin Township.
Jeff,
Yes.
I was looking at that and if you look at 27, the same section, zoning permit, but 1B instead of 1A. You see it refers there to 27-1405, which is equivalent to 1303 in the flood hazard district. And then it refers to 27-1409, which that was permits for special exemption rather, I think, which parallels 1308, which is permits for variance. So I was wondering if it should refer not only to 1303, but 1308.
Well, I think we're going into two different sections. The flood hazard district is, you want it regulated by FEMA for floodplains, whereas the conservation district and steep slopes would be regulated differently. And we have the ordinance for that. And that's why in 2309, that's why they're separating A and B. So there's a distinction between the flood hazard district and the conservation slope district.
Right. I wasn't questioning that. What hang on, I'm trying to flip back and forth.
Yes.
Between different parts of the code here. All right, I gotta go up further. So you were saying, I need to read this again.
See, 1409 and 1405, I couldn't apply to section A.
No, I understand that. I wasn't suggesting they would be applied. I was suggesting that the parallel sections in 13 was not 1309, but was 1303, the entire 1303 and the entire 1308.
I follow. You just want to expand it a little bit to make sure we're covered in chapter 13 or section 13.
Yeah, in other words, that section 1B there sends you to both 1405, which is the administration section, which parallels 1303, which is also the administration section. And then they additionally throw in 1409, which is standards for application for a special exception.
Right.
And so my thought was that to some degree, 1308 is a parallel to that.
Yeah, I follow your thought process, and we certainly could add 1303 and 1308.
I'm sensing from the rest of our silence, either we all agree or we're not really following what Paul's saying.
I'm not following it, but since Jeff and Paul agree, I'd go along with it once I understood it better.
I'm going with option B.
Take the fifth.
So we're adding 1303 and 1308 to this section 27 or 23, this statement, that content statement. Did I just throw you off?
Paul, do you agree with that?
I think so.
So 1309 and 1310 are wrong.
Should be
Okay.
1303, correct?
So, but 1303 and 1308 work, correct, Jeff?
Yes. It gives you the administration and the opportunity for variance in both the flood hazard and in the conservation steep slope area.
So we're just swapping out 1309 and 1310 for 1303 and 1308.
Yes.
I think that's right.
Okay, gotcha. Okay. Do we have to have Mark's approval on that?
No.
I don't think so.
No.
All right.
I'm gonna get him to look at all of this when we have it all marked up, you know, in a clean copy.
Okay.
Okay, 26. I know.
Again, I would say there, I looked at that and their revision would appear correct to change it to 22-613.
Revise as suggested.
Do we have notes on what the recommendations were for question 27-003? That would be last time around.
That was hearing versus meeting.
Yeah, but there was all kinds of public notice stuff in that, wasn't there?
Shouldn't we just go with what the MPC is saying?
That's what I would think.
Have you moved on to 27?
I think we move on to 27, yeah.
Well, just to go back to 27003, my notes say that we're going to have the solicitor review and then Mark to review for public meeting, not a public hearing. That, just so you know. Paul.
Yeah, so yeah, the reason I bring it up is because they're referring to that section here in their second paragraph.
The legislature is working on changing all of this so that things could be advertised on our websites electronically instead of going into newspapers. So I'll talk to Mark about this, and you know, by the time we get this all done, hopefully it'll be they'll know what they're doing in Harrisburg.
Good luck.
Yeah, because these are two very different sets of requirements. currently we're required to advertise twice, once in 1 week and then once in a second week. This says, so publish the proposed amendment once instead of twice. And then you can do it as early as 60 days or as late as 7 days. Which is a lot more flexibility.
I would say that if it's going to change again imminently,
Oh
we
yeah,
would,
I wouldn't
we
touch
would
it.
just not do anything with it and wait for it to change.
Yeah.
I'll see what Mark says.
My paper boy doesn't come around anymore since his horse threw his shoe.
So is this for Mark's review?
Yeah.
I knew we were a rural community. I didn't realize we're still that rural.
Well, I have been behind horses around here, so yeah.
Were they delivering a paper?
I'm not sure. I didn't wait to find out.
They were picking them up, recycling them.
Yeah.
Could be.
Okay.
Are we on
We're working on
28?
28.
Right.
And that's just a mistyped number there.
Mhm.
So that's revised as suggested.
Yep.
Yeah.
$29.
Is this like some sort of crossword puzzle?
Something's
You're
definitely missing
trying to figure
here.
out what word is supposed to go in there.
Actually, Jeff solved this one already. I read his notes.
What's the answer?
The answer is remove and shall out of the yellow highlighted part.
Okay.
Great.
That
I'm good
seems
with that.
reasonable.
We're removing and shall. Is that what you said, Paul?
Yeah, that's what you said. I'm quoting you.
All right.
I didn't know I commented on that.
Yes, you did.
And one last time, we'll talk about timber.
Yes. Does this get into acres as well, an acres issue?
I think they're saying that this is pointing to the wrong numbers.
Yeah, I think they're right too. Given that there's no subsection 7, that's clearly not the right reference.
Yeah, they're saying to refer to subsection 6.
Right.
But does it count at all if the state is getting involved with this?
Well, again, we're going to ask Mark to weigh in on that.
Yeah.
But if we can do something, then it should be what they say revised says
Yeah.
suggested.
Okay.
Okay. Then 31.
That's a revised as
Revised
suggested too,
suggested,
right?
yeah.
Yep.
Right.
Now, Chuck, you'll be pleased to know they have a typo in their second option because it's not a comma two, it's a period two. So you should mark that up and send it to them.
Send it back. It should go back.
You realize how much that's gonna cost us?
Are these are our consultants?
They manage our ordinances. They do the codification.
Okay, don't send it back.
Are we
Okay,
done?
then the Board of
That's it.
Supervisors meeting is on the
17th.
17th. I don't believe I have a conflict.
Okay.
Is there a HARP presentation?
I nominate Paul.
Oh, God. Is there a hard presentation? I wouldn't know. I only sent them 60 pages or so.
Mark is working on it.
I assume that's going to be up for discussion, the COA application.
Right. Well, Mark he'll know as of tomorrow whether we're going to put it on the agenda or not. There are other chapters here that the PC doesn't normally deal with. That
Do we have a plan coming in next month?
Your guess is as good as mine. I don't know where Nori went.
I'm aware.
Pardon?
Okay.
Yeah. But anyway, we have to go over these other chapters. Like Jeff and I will go over them and see if there's any that Mark has to weigh in with these chapters also. And then I want to just give him one whole set to look at. So I don't know if we're going to, if he'll have this done for you next month. We have to see where he is with this. And then I'd like you to look at it again before it goes to the board. When Mark comes up with his, he may say you could do this or that or whatever. Is that okay? Or
Okay.
So Joan, do
We
we have,
guess so.
so I just kind of want to summarize. So all the comments we've made throughout the review so far has to be written up and put in a clean copy.
right,
then-
we're going to have a clean copy of this, Mary, and we'll mark it up. Like if it's revised as suggested, we'll just mark that box. But if there are some
Suggestions, we'll add it.
language that we want in there, we'll put that in, and then we'll also check with Mark for the information that he has to provide.
So
then we'll have
it'll go back to Mark for review, and then from that, it'll come back to the board here.
Well, I think, do you want to see it again when Mark is finished with it?
The next meeting.
Well, I don't think he'll be done by next meeting. I mean, this will
Okay.
be a lot for him to go through.
So then I can go to Florida and not worry.
Yeah, you can go to Florida, not worry. But if a plan comes in, we'll let you know. But I don't think Mark will be done. But do you want to see this when he is done?
I don't think,
I
I
don't
personally
know.
don't think there was anything that groundbreaking that,
You have to look at again.
yeah.
Okay. All
that's
right.
my
So then
opinion.
we'll get Mark to review it, and then it'll go on to the board.
I'm also thinking about all the noxious weeds I may or may not have to get rid of it's going to be springtime. So
You don't want to go to jail.
that's right.
Just get rid of that thistle. Or your neighbors up the road up there will be upset with you.
I think I'm good with thistle. I don't think.
Yeah,
there's
we
any-
got enough of our own. We don't need yours, Chuck.
I don't think, well, that's probably, if I have any, I'll know where it came from.
There is a weed killer for thistle. Did you know that? There is a specific one that does kill thistle.
Yeah, that's what they sprayed in Goodwin.
Yeah, there's a specific one. They use it along with sometimes. They don't tell people about it.
Yeah. Okay, I guess no public comment.
Where's the public?
We'll adjourn at 8:46.
Okay.
Bye,
All
everybody.
right.
See ya.
Bye.
Bye.
No,
Bye.
Good night.
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 All right.